Do you need more time, or are you ready to segue in or ready the instructions?
I'm ready to go, Your Honor.
I'd still need to rest before you do that, Your Honor.
Oh.
On the record?
Yeah.
Yeah.
All rise, please.
Okay, thanks. You can be seated. Okay, I believe we're ready for the jury.
Should you do a copy of the instructions for me or no?
No, I thought you had said, you don't have.
That's okay.
You need a copy?
Nah, that's okay.
We'll burn you one after they
Okay.
come out.
Actually, Your Honor, I do.
Okay.
All rise, please.
Thank you. Please be seated. Okay, so jurors, the state has rested. Mr. Curry, at this time, are there any witnesses for the defense?
Your Honor, at this time the defense rests. Thank you.
Thank you. Jurors, the state has rested. The defense rests. I don't believe there are any rebuttal witnesses for, well, there are no rebuttal witnesses. At this time, I'm going to read to you the instructions on the law. You have copies of my jury instructions. You're certainly welcome to read along. And we'll start with instruction number 1. It is your duty to decide the facts in this case based upon the evidence presented to you during this trial. It also is your duty to accept the law from my instructions, regardless of what you personally believe the law is or what you personally think it should be. You must apply the law from my instructions to the facts that you decide have been proved, and in this way decide the case. Keep in mind that a charge is only an accusation. The filing of a charge is not evidence that the charge is true. Your decisions as jurors must be made solely upon the evidence presented during these proceedings. The evidence that you are to consider during your deliberations consists of the testimony that you've heard from witnesses, stipulations, and the exhibits that I have admitted during the trial. If evidence was not admitted or was stricken from the record, then you are not to consider it in reaching your verdict. Exhibits may have been marked by the judicial assistant and given a number, but they do not go with you to the jury room during your deliberations unless they have been admitted into evidence. The exhibits that have been admitted will be available to you in the jury room. One of my duties has been to rule on the admissibility of evidence. Do not be concerned during your deliberations about the reasons for my rulings on the evidence. If I've ruled that any evidence is inadmissible, or if I have asked you to disregard any evidence, then you must not discuss that evidence during your deliberations or consider it in reaching your verdict. Do not speculate whether the evidence would have favored one party or the other. In order to decide whether any proposition has been proved, you must consider all of the evidence that I have admitted that relates to the proposition. Each party is entitled to the benefit of all of the evidence, whether or not that party introduced it. You were the sole judges of the credibility of each witness. You were also the sole judges of the value or weight to be given to the testimony of each witness. In considering a witness's testimony, you may consider these things: the opportunity of the witness to observe or know the things he or she testifies about, the ability of the witness to observe accurately, the quality of a witness's memory while testifying, the manner of the witness while testifying, any personal interest that the witness might have in the outcome or the issues, any bias or prejudice that the witness may have shown, the reasonableness of the witness's statements in the context of all of the other evidence, and any other factors that affect your evaluation or belief of a witness or your evaluation of his or her testimony. The lawyer's remarks, statements, and arguments are intended to help you understand the evidence and apply the law. It is important, however, for you to remember that the lawyer's statements are not evidence. The evidence is the testimony and the exhibits. The law is contained in my instructions to you. You must disregard any remark, statement, or argument that is not supported by the evidence or the law in my instructions. You may have heard objections made by the lawyers during trial. Each party has the right to object to questions asked by another lawyer and may have a duty to do so. These objections should not influence you. Do not make any assumptions or draw any conclusions based on a lawyer's objections. Our state constitution prohibits a trial judge from making a comment on the evidence. It would be improper for me to express by words or conduct my personal opinion about the value of testimony or other evidence. I have not intentionally done this. If it appeared to you that I have indicated my personal opinion in any way, either during trial or in giving these instructions, you must disregard this entirely. Jurors, you have nothing whatever to do with any punishment that may be imposed in case of a violation of the law. You may not consider the fact that punishment may follow conviction except insofar as it may tend to make you careful. The order of these instructions has no significance as to their relative importance. They are all important. In closing arguments, the lawyers may properly discuss specific instructions. During your deliberations, you must consider the instructions as a whole. As jurors, you are officers of this court. You must not let your emotions overcome your rational thought process. You must reach your decision based on the facts proved to you and on the law given to you, not on sympathy, prejudice, or personal preference. To assure that all parties receive a fair trial, you must act impartially with an earnest desire to reach a proper verdict. Instruction number 2. Evidence may be either direct or circumstantial. The term direct evidence refers to evidence that is given by a witness who has directly perceived something at issue in this case. The term circumstantial evidence refers to evidence from which, based on your common sense and experience, you may reasonably infer something that is at issue in this case. The law does not distinguish between direct and circumstantial evidence in terms of their weight or value in finding the facts in this case. One is not necessarily more or less valuable than the other. Instruction 3. The defendant has entered a plea of not guilty. That plea puts in issue every element of the crime charged. The state is the plaintiff and has the burden of proving each element of the crime beyond a reasonable doubt. The defendant has no burden of proving that a reasonable doubt exists as to these elements. A defendant is presumed innocent. This presumption continues throughout the entire trial unless during your deliberations you find it has been overcome by the evidence beyond a reasonable doubt. A reasonable doubt is one for which a reason exists and may arise from the evidence or lack of evidence. It is such a doubt as would exist in the mind of a reasonable person after fully, fairly, and carefully considering all of the evidence or lack of evidence. If from such consideration you have an abiding belief in the truth of the charge, you are satisfied beyond a reasonable doubt. Instruction 4. As jurors, you have a duty to discuss the case with one another and to deliberate in an effort to reach a unanimous verdict. Each of you must decide the case for yourself, but only after you consider the evidence impartially with your fellow jurors. During your deliberations, you should not hesitate to re-examine your own views and to change your opinion based upon further review of the evidence in these instructions. You should not, however, surrender your honest belief about the value or significance of evidence solely because of the opinions of your fellow jurors, nor should you change your mind just for the purpose of reaching a verdict. Instruction 5. A person commits the crime of possession of depictions of a minor engaged in sexually explicit conduct in the second degree when he or she knowingly possesses visual or printed matter depicting a minor engaged in sexually explicit conduct. Instruction 6. Minor means any person under 18 years of age. Instruction 7. A person knows or acts knowingly or with knowledge with respect to a fact, circumstance, or result when he or she is aware of that fact, circumstance, or result. It is not necessary that the person know that the fact, circumstance, or result is defined by law as being unlawful or an element of a crime. If a person has information that would lead a reasonable person in the same situation to believe that a fact exists, the jury is permitted but not required to find that he or she acted with knowledge of that fact. When acting knowingly as to a particular fact is required to establish an element of a crime, the element is also established if a person acts intentionally as to that fact. Instruction 8. A person acts with intent or intentionally when acting with the objective or purpose to accomplish a result which constitutes a crime. Instruction 9. Visual or printed matter means any photograph or other material that contains a reproduction of a photograph. It is material that can be viewed with the human eye either directly or with the aid of a device that transforms it so that it can be viewed. Instruction 10. Sexually explicit conduct means actual or simulated depiction of the genitals or unclothed pubic or rectal areas of any minor, or the unclothed breast of a female minor for the purpose of sexual stimulation of the viewer, whether or not the minor knows that he or she is participating in the described conduct. Instruction 11. To convict the defendant of the crime of possession of depictions of a minor engaged in sexually explicit conduct in the second degree, each of the following elements of the crime must be proved beyond a reasonable doubt. 1. That on or about the 25th day of August, 2011, the defendant knowingly possessed visual or printed matter depicting a minor engaged in sexually explicit conduct. 2. That the defendant knew the person depicted was a minor. 3. That this act occurred in the state of Washington. If you find from the evidence that each of these elements has been proved beyond a reasonable doubt, then it will be your duty to return a verdict of guilty. On the other hand, if after weighing all the evidence you have a reasonable doubt as to any one of these elements, then it will be your duty to return a verdict of not guilty. Instruction 12. The defendant is not required to testify. You may not use the fact that the defendant has not testified to infer guilt or to prejudice him in any way. And finally, instruction 13. When you begin deliberating, you should first select a presiding juror. The presiding juror's duty is to see that you discuss the issues in this case in an orderly and reasonable manner, that you discuss each issue submitted for your decision fully and fairly, and that each one of you has a chance to be heard on every question before you. During your deliberations, you may discuss any notes that you've taken during the trial, if you wish. You've been allowed to take notes to assist you in remembering clearly, not to substitute for your memory or the memories or notes of other jurors. Do not assume, however, that your notes are more or less accurate than your memory. You will need to rely on your notes and memory as to the testimony presented in this case. Testimony will rarely, if ever, be repeated for you during your deliberations. If after carefully reviewing the evidence and instructions, you feel a need to ask the court a legal or procedural question that you have been unable to answer, write the question out simply and clearly In your question, do not state how the jury has voted. The presiding juror should sign and date the question and give it to the judicial assistant. I will then confer with the lawyers to determine what response, if any, can be given. You will be given the exhibits admitted in evidence, these instructions, and a verdict form for recording your verdict. Some exhibits and visual aids may have been used in court, but will not go with you to the jury room. The exhibits that have been admitted into evidence will be available to you in the jury room. You must fill in the blank provided in the verdict form, the words "not guilty" or the word "guilty" according to the decision you reach. Because this is a criminal case, each of you must agree for you to return a verdict. When all of you have so agreed, fill in the verdict form to express your decision. The presiding juror must sign the verdict form and notify the judicial assistant. The judicial assistant will bring you into court to declare your verdict. And those are the court's instructions on the law. We're going to take, are you all okay? You're up ready? Nobody needs a break? Maybe? Okay. I need to see Ms. Goodman and Ms. Olson at sidebar if possible, please. Cruz, give us just a second. Just need to make an adjustment.
All rise, please.
Okay, thank you. You can be seated. Jurors, at this time, I'm going to ask that you please give your undivided attention to Mr. Nelson for a closing statement. Thank you.
Thank you, Your Honor. Excuse me. Ladies and gentlemen, at the beginning of this case, I told you that this was relatively simple and that this is a case about the defendant, Stephen Powell's secret. And the secret in this case was that the defendant was possessing images that constitute possession of depictions of minors engaged in sexually explicit conduct in the second degree. Now, the instruction I'm going to focus on in particular here is what we refer to as the to convict instruction. And we call it that for a simple reason. The first two words of the instruction are to convict. It's instruction number 12 in your packet. Excuse me, instruction number 11 in your packet. You're welcome to look at it as we go along. You don't have to if you don't want to. Now, there's three things in this instruction that I must prove to you beyond a reasonable doubt for you to convict the defendant in this case. First, on or about August 25th, 2011, the defendant knowingly possessed visual or printed material depicting a minor engaged in sexually explicit conduct. Second, that the defendant knew the person in the depictions was a minor. And third, that the acts occurred in the state of Washington. So what I want to do is talk to you about really what's at issue in this case. So clearly, what occurred in this case happened in the state of Washington. There's no real dispute. So the third element's been met here. The testimony indicated that the images were taken from the defendant's bedroom, and the images were located on the disk in the defendant's house in South Hill, in Pierce County, in Powell. Not in dispute that this happened in the state of Washington. And frankly, clearly also, the images in this case depicted minors. There's simply no disputing that fact. You heard from D.C., she testified as to the dates of birth of her daughters. These were minors in these images. It's transparently obvious based upon the images as well. So the critical question for you in this case is, did the defendant, Stephen Powell, knowingly possess these images? And the evidence in this case answers that question for you. And the answer is yes. Now let's take a look at the evidence in this case. There are two minor girls filmed here, bathing and using the bathroom. You heard from their mother, D.C. A.H.'s date of birth is 9/27/96. She's the older daughter. J.H.'s date of birth is 5/22/98. She's the younger daughter. And D.C. told you they moved into that house in the summer of 2006, and they lived there through the summer of 2007. So these photos were taken between 2006, sometime in that time period, between 2006 and 2007, which means A.H. was either 9 or 10 years old, and J.H. was 8 to 9 years old. Clearly, both these girls are minors. The evidence, you heard from the detectives that went into the house, the evidence tells you where the girls were when the photos were taken. And clearly, they were filmed bathing and using their bathroom as depicted in the images that were admitted into evidence and you'll get when you deliberate. The evidence also tells you that Stephen Powell is the one that filmed the girls. And it tells you that because the girls were filmed from the defendant's house, from that back bedroom, into the window. That's the only place where this filming could have occurred. The evidence tells you that Stephen Powell filmed the girls because there's a camera found in the defendant's bedroom. And you heard from Ellis Maxwell. The model number of the camera matched the data on the images that were screen captured from the video. So we know that the images were taken with the camera, same model number that was found in the defendant's bedroom. We know that Stephen Powell possessed the images. And that's the real critical question in this case. Did the defendant possess these images? The answer to that question, quite simply, is yes. The images were found in the defendant's bedroom. Item number 45, that cardboard box, you saw photos of it, you heard testimony about it, was located in the defendant's bedroom. The images were found on a disc containing other photos of the defendant. And you heard testimony about those photos. There's photos of the defendant nude, masturbating, that sort of thing on this disc. Why are those photos there with the girls? Because it's the defendant's disc. So Stephen Powell possessed the images in this case. As I indicated, the images of the girls were kept with images the defendant took of himself. The images of the girls were kept with other photos of young teenage girls taken in the defendant's neighborhood. The images of the girls were on the same disc as photos of a young teenage girl in the defendant's former neighborhood. We know Stephen Powell possessed the images because no one else in that residence would have any interest in the photos on this disc. Why would anybody else want photos of Stephen Powell, nude, masturbating, engaged in that sort of sexual activity? His kids were living there. Why would they want those sort of images? The answer is they wouldn't. The person that wanted those images is the person that created them, and that's the defendant, Stephen Powell. Stephen Powell's motive, and we don't have to prove motive, but it's important for you to recognize that his motive in this case was his own sexual gratification. The images of the girls, of AH and JH, they focus in particular on their legs, their breasts, their buttocks, and their vagina. And most crucially, the defendant himself admitted in his journal, which you will have back with you when you deliberate, that he likes to take video of girls for purposes of self-stimulation. Detective Sanders talked about, and you saw in the images, Detective Sanders described it as looping. What it is when the defendant made the screen captures, he went back to particular images, and when you viewed all those images, if you notice, the images that he went back to and re-screen captured were inevitably the images of the girls where they were nude, where it zoomed in on their genitalia, and that sort of thing. It wasn't the images where they were clothed. There were very particular images that he kept re-screen capturing. And that's because the defendant captured these images for his own sexual gratification. The images on that same disc contain numerous other sexually suggestive photos, as was testified to by Detective Sanders and Sergeant Gray. Those images were of the defendant himself. You saw the images of the two girls. Inevitably, the images zoomed in on their genitalia when they were nude. And there's simply no other reason to film these two girls under those circumstances than for your own sexual gratification. There is none. So why in this case is the defendant's motive important? Well, your instructions define sexually explicit conduct. And you just heard the judge read that instruction. As I indicated, normally the state doesn't have to prove someone's motive, their motivation. But in this particular case, your instructions tell you that sexually explicit conduct is actual or simulated depiction of the genitals or unclothed pubic or rectal areas of any minor or the unclothed breast of a female minor for the purpose of sexual stimulation of the viewer, whether or not the minor knows that he or she is participating in the described conduct. It's important to unpack that instruction a little bit. The latter part talks about the minor depicted doesn't have to know that they're a part of it. So in this particular case, obviously the two girls had no idea that they were part of it. They're in their house. The defendant's taking these pictures from his bedroom, but they don't have to know that they're a part of it. Obviously, the images in this case are an actual depiction of the genitals or unclothed pubic area or the unclothed breast of the girls. So obviously, that's what these images are. That's proved beyond a reasonable doubt. You've seen the images. Clearly, that's what they are. So the question for you, the real question as to this instruction is, were these images kept, possessed, for the purpose of sexual stimulation of the viewer? And the answer to that question, quite simply, is yes. And I've discussed that already in detail. Ask yourselves, how do we know that these images were used by the defendant for sexual stimulation? Well, number one, there's circumstantial evidence because of all the other images on the disc of the defendant engaged in sexual activity. So they're on the same disc as those sorts of images. So clearly, they're bundled together. But perhaps more importantly, the defendant's own words, the defendant's journal entry, tells us that these images were used for sexual stimulation. You'll have the journal entry in this case. The journal entry tells you, I enjoy taking video shots of pretty girls in shorts and skirts, beautiful women of every age. I sometimes use these images for self-stimulation. That's it. The defendant tells you in his own words what these images that he took are used for. He uses them for self-stimulation. He uses them for his own sexual gratification, as is required by your instructions. So the defendant's own words prove to you beyond a reasonable doubt what these images were used for. You already know who they're of, who took them, who possessed them, and now you know what they were used for. So at the beginning, I talked about the to convict instruction. And there's three things that the state has to prove beyond a reasonable doubt. First, the defendant knowingly possessed visual or printed material depicting a minor engaged in sexually explicit conduct. Clearly, that's what he did here. These images were in the defendant's bedroom. They're in a box under other boxes. They're on a disc with images of the defendant engaged in sexual activity by himself. And they were taken by the defendant from his bedroom. So that element's been proved beyond a reasonable doubt. Second, the defendant knew the person depicted was a minor. There is simply no argument to be made that the girls contained in these images were anything but minors. It is transparently obvious to anyone that views them. It is obvious that these girls are minors. So that element has been met beyond a reasonable doubt. Third, that the act occurred in the state of Washington. Obviously, that's been met beyond a reasonable doubt. So, ladies and gentlemen, in the end, as I told you, this is a simple case. The defendant had a secret that he was able to maintain for almost 5 years. But on August 25th, 2011, the defendant's secret came out. The defendant's secret was that he possessed depictions of minors engaged in sexually explicit conduct in the second degree. The evidence proves to you beyond a reasonable doubt that the only appropriate verdict in this case that is justified by the evidence is guilty. And I ask you to return a verdict of guilty. Thank you, ladies and gentlemen.
Thank you, Mr. Nelson. Jurors, at this time, I'm going to ask that you please give your undivided attention to Mr. Curry for closing argument.
Thank you. Well, I think I remember correctly at the beginning of this trial, I told you to reserve your judgment, not let us get ahead of ourselves too far. And is anybody familiar with the phrase, close only counts in horseshoes and hand grenades? I think that's applicable here for a number of reasons. One having to do with a lot with the law, and one having to do a little bit more with the type of evidence we have on this case here. I'm going to write something up there in a little bit, but have that ready. I want to first talk about the law that you finally have in front of you, the instructions that the court gives you. And we alluded to some of this, I think, to some extent. We often do in our conversations with the jury ahead of time and when we're doing our opening. Remember, nothing that you heard here, nothing I'm saying here is evidence any more than it was before. This is still our time to argue to you what we think the evidence shows. Okay? So the fact that counsel says, oh, we proved it beyond a reasonable doubt doesn't mean anything. That's your call. You're the jurors in this case. But when you're a juror, how are you supposed to look at the evidence? How are you supposed to consider the evidence? This isn't like, well, the question isn't what you think likely happened here. You're not supposed to be like any kind of genius detective or something, and it's not your job to solve the case. It's your job to decide what has been proved by the evidence that you heard in the case, what you've heard from this witness stand here, and what those exhibits actually prove. And when we talk about proof, we're talking about beyond a reasonable doubt. I'm going to get back to that. You'll hear me say that several times. But when you look at the evidence, what are the very first instruction? What are some of the really important things, and why is this apparently a simple case, like a lot of simple cases, not quite as easy as it at first appears? The reason is you're not supposed to, and your instructions tell you, making decisions based on passions, emotions, and those sorts of things. You actually have to take what your gut tells you out of the equation. You're supposed to decide a case logically, based on what the evidence actually proved. The instructions tell you that. It says, the very first one, you can't let your emotions overcome the rational thought process. Now that can be very difficult in a case like this. I know when you first saw those images up there of the young girls, we heard rustling of the papers, your pads of paper. perfectly natural reaction, right? Some visceral reaction you had. Nothing wrong with it. You're not robots. You're not expected to be. But when you evaluate the evidence, the instructions tell you have to do what you have to take that part and separate that a little bit, and then say, okay, well that doesn't. I don't feel good about that. I wasn't happy having to look at that. I'm not happy with the suggestion or the idea that somebody might be using that or looking at that or possessing it for these sorts of purposes. Right? Makes you feel icky. Perfectly okay reaction. You're allowed to have that. I'm sure you all did. Should have it. But according to instructions, you have to separate yourself from that when you're deliberating, when you're considering the evidence and trying to figure out what they actually proved. And the reason I'm kind of stressing that right here at the beginning is because this is exactly the same kind of case where that is actually hard to do. But you've taken an oath. You all said at the beginning, might not like having to do this kind of case, but I believe I can do that. So you have to, step one, right? When looking at this evidence, you got to separate your gut reaction a little bit from what was actually proved. Okay? So let's start. If you're doing that, we have this case. I'll submit to you is a lot. There's a lot of circumstantial evidence here. Okay, you have specific testimony that it occurred in Washington, and you haven't heard that anything didn't occur in Washington. So I agree. Count those elements, and that when we talk about to convict, that specifically tells you that each one of those elements are the things that the state has to prove beyond a reasonable doubt. They don't have to prove that that it was Sunday or that it was sunny or anything else like that. They have to prove those specific elements beyond a reasonable doubt. So did they prove that what happened in Pierce County, Washington? Yes. You can skip that. You can say, yeah, okay, they proved that. Did they prove that the AH and JH, were minors? Yes, we know their dates of birth. They were minors at the time. The law tells you under 18, they are minors. You can check that one off too. Okay? So I agree. What we're looking at is element number one. When you look at element number one, you have to find, in order to convict, and counsel glossed over a little part about it. Remember, this is on or about the 25th of August in 2011. On or about the 25th of August 2011 does not mean in 2006. On or about is regular English words. Okay? You use them. What does on or about mean to you? Well, I would say on or about means the 25th of August, 26th of August, 27th, right around there, right? 2011. Okay? And on that date, around that date of August 25th, 2011, was it Mr. Powell? And did he knowingly possess them, these images? And did he do so? Normally motive isn't an issue, but the element is for that purpose. That these are depictions of minors engaged in sexually explicit conduct, and they have to be, because they were not, the conduct itself isn't some automatically sexually explicit. It's sexually explicit because of why it was maintained, why it was possessed. What was the purpose of that viewer had for having those images, right? Each of those things, when we talk, so that element has to be proved beyond a reasonable doubt. Beyond a reasonable doubt is repeated in your instructions numerous times. It's in the section when it talks about they have to prove each of these elements, so you know exactly what we're talking about has to be proved. It also is in there, there's instruction earlier on that talks about that the defense has no burden whatsoever. The state has the burden of proving the case beyond reasonable doubt, and then it tells you what a reasonable doubt is. A reasonable doubt is a doubt for which there is a reason. That sounds a little bit like a tautology, I know, and it can be based on the evidence and or lack of evidence, and it's such a doubt as would remain in would be in the mind of a reasonable juror after fully Carefully, fully, fairly, carefully considering all of the evidence or lack of evidence. Okay? And that you have to have then an abiding belief. If you have an abiding belief of the truth of the matter, you've been convinced beyond a reasonable doubt. Under the law, we have multiple different kind of levels of proof that we talk about. We talk about a simple probable cause. Some reason to believe that something may have occurred. It's probable cause. It's way down here. Okay? We have, in civil cases, we have preponderance of the evidence. Okay? Preponderance of the evidence means simply more likely than not. So it's literally 51% or 50 plus. More likely than not. So that's preponderance. That's how if you decide a civil case, generally. All right? We have a higher burden in cases that are called, that we use for, they're mostly about welfare of children, whether they should be in dependency cases and termination cases, about whether parental rights and things like that. And what we call that level clear, cogent, and convincing evidence. Okay? Think of those words. Clear, cogent, and convincing. Okay? That's lower than beyond a reasonable doubt. Okay? So if you're convinced by clear, cogent, and convincing evidence, you still haven't yet reached the level under our law, the highest burden we have, beyond a reasonable doubt. And I often do this during my closing arguments and reach up here, and when I was younger, that seemed higher. But just assume for a minute that I'm standing on a chair when I do that, okay? I don't want to fall and trip and fall and hurt anybody, but beyond a reasonable doubt is the highest burden under the law that I could reach up here, okay? Now, it does not mean beyond any doubt, and by that we mean a doubt for which there is no reason, okay? The state doesn't have to disprove that maybe aliens did it. Okay? It's a reasonable juror considering the evidence. Okay? But when you look at what the evidence proves, what they have here is, I would submit to you, something that's in the nature of, it's close. Okay? Maybe you think more likely than not. Maybe you think, yeah, probably based on what I heard, he did it, he possessed for these purposes. And he knew about it. He knew he actually possessed it. I submit that's probably where you're at this point. You haven't gone, you haven't considered, you're not deliberating yet. But you may start out from that position. Oh, that doesn't get you there. Because even though the instructions tell you you can look at circumstantial evidence, and that circumstantial evidence is not necessarily any worse than straight up regular evidence, circumstantial evidence is really only as good as how assured you can be that that outcome that it suggests has to be true. Right? So what we have here is a lot of circumstantial evidence. Now let me describe what I'm talking about when I say circumstantial evidence. These items were found in the house of Stephen Powell. Right? Okay. But does that prove, do you know of everything that's in your house? If you have other people living there, do you know everything that's in your house? Well, you probably know a lot of stuff's in your house, but it doesn't prove, it's circumstantial evidence that it was either his or he knew it was there, right? It's in a box in his room, right? More likely, that makes it more likely. That's circumstantial evidence. Right? Okay, but first of all, let's start off. Was the pictures we saw, we know that a lot of stuff was taken out of the house. A lot of computers, a lot of disks, a lot of digital media. So there's apparently computers and stuff all over the place. You saw the picture of the box where the disk was found. It's in a stack of boxes in the corner of what purports to be his room at the time. Right? But there's not a label on the box. Right? That would be better circumstantial evidence. There's not a label on the disk. That would also be better circumstantial evidence. Now, yes, they have other images of Stephen Powell on the disk. That is good circumstantial evidence for them. But does it prove that he knew about all the other images on the disk? let's remember, you can't tell from that box how long it's been sitting there. Can't tell how long since it's been opened. We can't tell if any of these images were ever looked at again since their creation. We don't know if they've ever been accessed on any other device. This is all the evidence we have here. We know that there's a camera, that the model number matches information contained in those images, right? But we can't tell if it's the actual camera. We just know that a model, similar, that same model number camera. Also pretty good that it was taken with that camera. But who took it and when? Can't tell that for sure from what we have. We can say likely. We can say pretty good circumstantial evidence. But that is not the question. The question is beyond a reasonable doubt. So they have location, okay? They have proximity based on a box in the room. They have the camera, which is similar, and then they have other images of the disk, and then they have the journal entry, right? Which may or may not have been taken from 2004. That journal entry, also circumstantial evidence. It didn't say, I like to look at images of naked underage girls. You read that, you got the journal entry, you'll have it back there to read. It talked about women in clothing. It also didn't specifically address any of these images. It wasn't contained, it wasn't packaged, it wasn't wrapped around this disk. That these are the ones, these are the images I'm talking about. Now, circumstantially, you might go, well, it does seem to be talking about that. Absolutely true. That's why this case, although apparently simple on its face, is not quite that simple, because what you don't have any direct link that says it has to be him. Again, not beyond any doubt, but if you have a reasonable doubt, if it could have been somebody else, or it could be there and him not know about it, then under your instructions, you have to return a verdict of not guilty. All of the evidence is of that nature in this case. Nobody can tell you who took the photographs beyond a reasonable doubt. Nobody can tell you who looked at the photographs beyond a reasonable doubt. Nobody can tell you that Mr. Powell knowingly possessed that disc or those photographs beyond a reasonable doubt. Just because there's other pictures we heard about that have nothing to do with it. Somebody's graduation, pictures of the trees, thousands of pictures, or hundreds of folders, thousands of pictures, and that's just that disc. If we were talking about discs all over if we found 100 discs in his room, that would be additional evidence you could pile on and say, well, could he not know one disc is there? Okay, probably difficult to say he didn't know 100 discs were there, because he'd be tripping all over them every day. But it's in a box in the corner, right? The box had a lid on it when they found it, and there were a lot of other boxes. And there was a lot of other stuff. They took a whole truckload of stuff back to Utah, and all those deputies spent all that time looking through all that stuff, and eventually these 3 folders are what brought us here today. If there had been tons and tons of that stuff, wouldn't be much of a question now, would it? But when that's all you got, you might say, under these circumstances, I think more likely than not, it was he took it or he knew about it. It was his. It was there, and that's where those purpose. That's what that purpose was for. I agree. You get to that point. That's not the question under the law, and that's what makes it difficult. That's why it can be tough on these sorts of cases to go, okay, well, and you might try as a way to do this. Pretend, I don't know, let's talk about, let's assume they're, I don't know, apples. Okay? Well, no, they'd actually have to be little tiny pictures of apples contained on one little disc in a box and all that other stuff. But to try to, I guess, remove, what I'm asking you is, when you're figuring out everything else except the part about the motivation, right? That it was for sexually explicit purposes. You got to figure that part out too. But I'm suggesting, remember when you're looking at these elements, you got to decide them all, whether they proved each parts of it completely beyond a reasonable doubt. Figure out, okay, well, was it for that purpose? Okay. And look at the journal, which goes to that issue, and the looping picture and cropping and stuff that you talked about would be evidence that would tend to discuss or would tend to prove that part or not, right? But when you're looking about the questions of whether Mr. Powell himself, not somebody else, he knowingly possessed on or about this date, I would suggest it might be easier to discuss it when you're not talking about what it is, the icky part. That might be a good way of trying to think through that and doing what you're supposed to do in your instructions by separating that part out. Again, we know that's hard, but that's how you got to do it. This isn't a case where you get to say, well, or it's a criminal case, and you don't get to, when you're talking about checking everything at the door, you don't get to just, I'm sorry, you don't get to get off easy by going, well, I think they proved it, so I don't want to, let's get out of here. You have to do it, and that's what you took your oath to. That's the tough part about being a juror, and when you're a citizen and you agree to come up here and a juror, and I know you all did that, and you all showed up. You're the good ones that are here. So you have to do that. So I'm asking you to do your job and look through the evidence. And I don't mean to do that to dismiss in any way that it's hard. I know it's hard to do that. But consider what was really proved beyond a reasonable doubt, and what is just more likely than not. Okay? Because you don't get to substitute more likely than not for beyond reasonable doubt. And I know you're all been paying very close attention to this case. I do appreciate that. I know it wasn't necessarily easy to hear every little piece of this. But look at carefully your notes as to what they showed. Because I will submit to you, you didn't find anywhere in here, the closest thing they got is the pictures of him on the same disc. Other than that, it's just proximity. And we're talking knowingly possessing those images on or about August 25th, 2011. Could the disk have been copied, burned? Could this be the entire contents of a hard drive of one of the multiple other computers that have been through this household, presumably in the last, 5 years? With that many computers in the household, how many times do you think they've gotten new computers and tossed out old ones between 2006, when we know the images must have been taken, and 2011, the period we're talking here? Could that be the contents of some hard drive of some computer that's been gone? And do you necessarily know about the contents of every single image on every computer in your household? I think we might like to believe that we do know that, but can you say that with any assurance if there's other people around who've had access to your computers? Again, thank you. I appreciate your listening hard through this case for the entire time, and thank you for doing what I believe, although the case was short, is not an easy job, and that's actually applying the law to the evidence you heard in this case the way you're supposed to. And that's all that we can ask you to do. And I think if you do that, you're going to look at that, and we confident you're going to return a verdict of not guilty on this case. Thank you very much.
Mr. Curry, jurors, the state has an opportunity for rebuttal because they have the burden of proof, and Mr. Nelson.
Thank you, Your Honor. Ladies and gentlemen, Mr. Curry asked an interesting question at the end of his closing argument. Do you know the contents of every computer in your household? You know what you know? Whether you have naked images of young girls on your computer. I'm pretty confident everybody can say either yes or no to that question. Hopefully the answer is no. And in Mr. Powell's case, the answer is yes. And we know the answer is yes because of his journal entry. He tells us that he has these images on the disk. He tells us. So we know the answer to that question is yes. We know that he possessed them because he told us so by his journal entry. Mr. Curry talked about reasonable doubt in his closing argument, and your instructions define reasonable doubt for you. The key word when you're debating reasonable doubt, when you're deliberating, is reasonable. Your instructions tell you that if the case has, if you have an abiding belief in the truth of the charge, then the case has been proved to you beyond a reasonable doubt. And an abiding belief, a belief that abides, is a belief that endures. It's one that you're confident in today, tomorrow, next week, next year. And the evidence in this case gives you that confidence to have an abiding belief in the truth of the charge. Defense counsel talked about circumstantial evidence, and your instructions tell you circumstantial evidence is no different than direct evidence. And yes, there is circumstantial evidence in this case. Doesn't mean that it's not evidence. Doesn't mean that it doesn't prove beyond a reasonable doubt that the defendant possessed these images. The circumstantial evidence in this case proves beyond a reasonable doubt that the defendant possessed these images. The defendant clearly possessed the images on August 25th, 2011. Defense counsel is right. You haven't heard any evidence of when the defendant viewed the images. The defendant's not charged with viewing the images. The defendant is charged with possessing the images. And he possessed the images on August 25th, 2011, because that's when the warrant was served. That's when the disk was found in his bedroom of images that he had created that were on this disk. Defense counsel's correct that the highest burden is beyond a reasonable doubt, but it's a burden, not a barricade. It is not beyond all doubt. It is not beyond any doubt. It is beyond a reasonable doubt. Defense counsel, again, asked, do you know of everything that's in your house? You're certainly going to know whether you have images of minor girls taking a bath, nude, that you've screen captured and looped over and over and over again. And again, the defendant knew that these images were in his house because he clearly created them, because the images were taken from his bedroom. They're screen captured from a video that obviously only the defendant was in a position to make. Defense counsel said there's no label on the disk, there's no label on the box. That's true. Unfortunately, the defendant did not write on the disk depictions of minors engaged in sexually explicit conduct. We don't have to prove that. Your instructions don't say that anywhere. Obviously, when someone possesses images of these nature, they're not going to put a giant neon sign out there to guide someone to them. Yes, the disk didn't have any markings of that nature on it. Would you expect it to? No. What's important is what was on the disk. Images of the defendant in folders, essentially next to the images of these girls. And again, it's important to remember that the defendant is not charged in this case with viewing depictions of minors engaged in sexually explicit conduct. He's charged with possessing them. And possessing them on a disk is no different than if there were printed pieces of paper in his room. It's exactly the same. Defense counsel talked about the journal entry in this case. And the defendant, in the journal entry, defense counsel indicated that he did not say that he liked viewing images of naked underage girls. I submit to you that's exactly what he said in that journal entry, that he enjoys videoing girls of any age, pretty girls of any age. That includes underage girls. And he also indicated that he uses the images for his own stimulation, for self-stimulation. Your instructions tell you that you are the sole judges of credibility of witnesses, and you determine what value or weight to be given to the testimony of each witness. And therefore, you also determine the value of the evidence that they present to you. And I submit to you that really what your instructions are asking you is what makes sense, what is logical, and what is proved by the evidence. And defense counsel's version of events in closing essentially requires you to believe that there are a huge set of random coincidences, all of which happen to go against the defendant. That doesn't really make sense. The more logical explanation is the explanation that is proved to you by the evidence in this case beyond a reasonable doubt. The defendant took a video of these girls. The defendant took screen captures of this video and burned them to a disk. The defendant then continued to possess the disk, which clearly was the defendant's, because he put images of himself engaged in various sexual activity on the disk. He possessed this disk for his own gratification, because he tells you that. He continued to possess the disk all the way through August 25th, 2011, when it was found in his house during the service of the search warrant. The logical explanation in this case is the one presented by the state because it's proved to you by the evidence. It makes sense, and it's proved beyond a reasonable doubt. Now, defense counsel argued, could these photos have been the contents of some other computer? Well, there's no evidence to support that. The evidence in this case is that the defendant is the one that possessed these images because they're found in his bedroom. His daughter tells you this is his bedroom. There's no evidence at all in front of you to indicate that anybody else lived in that room. It's the defendant's room. It was his stuff in the room. It was in a box of possessions in his room alongside images of him. The evidence in this case is clear, ladies and gentlemen. It proves beyond a reasonable doubt that the defendant is guilty of possession of depictions of minors engaged in sexually explicit conduct in the second degree. I ask you to return a verdict of guilty. Thank you.
Thank you, Mr. Nelson. Thank you again, Mr. Curry. And thank you, jurors, for listening so attentively. I'm going to need to speak to counsel at sidebar, and then we'll try to get this moving. Okay, so jurors, we're about ready to start deliberations, and there are some housekeeping matters we need to go over regarding deliberations. So you can now take your notes, your notepads, and your jury instructions back in the jury room with you. The first thing you need to do is select a presiding juror. I'm going to ask the presiding juror to work with my judicial assistant, Ms. McGoodwin, about your hours, because you can pretty much come and go as you please. You can do working lunches if you want. You can bring baked goods in the morning if you are still deliberating. But you cannot deliberate when everyone's not at the table. So if somebody takes a restroom break, then deliberation stop. If you decide to take a break and a couple of jurors decide they're going to take a walk in one direction and some others stay here and some others walk up to the store, deliberation stops. So when you're alone with the other juror, don't talk about the case. We want everyone to benefit from each other's knowledge and to be at the table when any deliberation happens. Jurors 13 and 14 are going to be the alternates in this case. Juror 13 and 14, you're going to remain under our orders not to discuss the case among yourselves or with anybody else. In the event that you're called back to deliberate, deliberations start all over. So, for example, you don't say, oh, well, welcome back. We've finished element 1 and element 2 or element 3. You start all over with the deliberations with the alternates. Again, the intent is for everyone to have the benefit of everybody else's ideas and knowledge and notes and wisdom to the extent you want to share your notes. I believe that's it. I'm going to give juror 13 and 14 a chance to go in and get stuff and say goodbye to all of their friends. I hope this was a good experience for everybody so far, particularly the alternates. And unless there are questions, we're going to be at recess. Yes, ma'am.
In a criminal case, if one or more jurors say no, he's not guilty, and then the rest says the other option, what happens then?
You have to look at your instructions, okay? All I can tell you is that the jurors need to be unanimous to return a verdict. Okay? Thank you. We're adjourned.
All right. Go ahead and bring your answer to the jury room. I'll be there shortly.